Folks, we're back. This is Steve Sands and Stephanie Phillips with another episode of Veterans in Politics. Today we have Adriana Rincon White, Clark County District Court Judge, Department Y, Family Division. But before we get to Judge White and Ms. Phillips, I just want to let everybody know, because everybody's been saying why I put my head down every time Ms. Phillips starts to rant and give her public service announcement. The reason why I do that is because I'm sharing the show live. So it's no disrespect to the guests or Ms. Phillips. So I just want to put that out there as a disclaimer.
Thank you. Glad you said that. And another disclaimer, whatever I say, we say in our rants and all these signs, has nothing to do with our guests. It's not their opinion. But anyway, thank you for joining us. And thank you to all of our sponsors. We have Semper Fi Heating and Cooling. It's hot out there, and give them a call to get your system checked. Their website is callsemperfi.com. Callsemperfi.com. Also, we have Michelle Romero. She's Henderson's mayor, and she's running for re-election. Her website is votemichelleromero.com. Votemichelleromero.com. Also, we have a board of regents candidate for District 3, Angelo Carvalho. His website is carvalho4nevada.com. That's the number 4, carvalho4nevada.com. Check out his website and his platform. Also, we have Cody K. Whipple. He is a congressional candidate for District 4. His website is codykforcongress.com, and that's the number 4 again, codykforcongress.com. Check out his platform and get in touch with him. Also, don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. You can get a copy on Amazon. It is $14.99. If you do not have an attorney or you can't afford one and you're in the family court system, this is a self-help book and it will help you navigate that system. So grab your copy. Also, we have a merch store. It's VIPImerch.com, VIPImerch.com. We have all kinds of fun stuff on there. And our consulting website is VIPIconsulting.com. If you are in need of a campaign manager, get in touch with us and check out our website there. Also, grab your tickets to the Valentine's Ball. It is February 7th of 2026. They are on sale as extra early bird tickets now for $99. We have never sold them that cheap, and they're on for the rest of the month of August. And there's only so many of those to go around. After that, the price goes up. So grab those early, and we look forward to seeing you there. For my rant, gosh, it's been a rough few days. I think you guys probably saw the decision to not indict Officer Alexander Bookman. He was involved. It was an officer-involved shooting. He shot Brandon Durham.
I am so frustrated with this process. I'm so frustrated with this DA's procrastination to file charges. I am devastated that he hasn't filed charges.
Brandon Durham was killed last year on November 12th inside his house. Metro Police Officer Alexander Bookman shot him after Durham called 911 to report a home invasion. This is body cam video from the other officer who responded that night, appearing to realize Bookman shot the wrong person.
Now, I reached out to Clark County District Attorney Steve Wolfson for a comment, and I'm still waiting to get a response. Reporting live at the Regional Justice Center, Joshua Peguero, 8 News Now.
And this happened November 12th of last year. And Brandon Durham, he was 43 years old. He called the police, said there was an intruder in his home. Officer Bookman came to his home 2 nights in a row. The night he shot him and killed him, and the night before. So Officer Bookman, when he walked in, the intruder was there. She had on a hoodie. The homeowner was in his boxer shorts. Clearly, you could see who the homeowner was and who the intruder was, and the fact that the officer had been to the same house the night before and talked to these people and knew who they were. So it's unfortunate that Mr. Durham was shot and killed. The officer shot him once in the head, went over to him. He told him to drop the knife. There was a knife involved. He said, drop the knife. Less than 2 seconds later, shoots him in the head, walks over to him and unloads 5 more rounds in this guy while he lays lifeless on the ground. Grand jury decided they're not going to indict him. David Roger defended him, saying that he was doing his job. And I would just say these grand jury proceedings, these are secret. The public doesn't get to see what they present. The prosecution gets to select what evidence the grand jury sees, which I don't think is fair at all, because we have no idea. There was a video of this shooting, so you can see what happened. And I don't know if the prosecution even presented the body cam footage and the video of this officer shooting this poor guy. So the fact that it's secret and we don't see what happens, they can pretty much do and tailor that case however they want to. I in this particular case, I think it's absolutely egregious. The officer is still on paid leave and he's only 26 years old. I would say this guy needs some training. If you can't determine who the homeowner is and who that intruder is, especially when you were there the night before, and then you go and unload your weapon and the guy is already on the ground. I mean, to me, he probably could have used pepper spray or a taser. It's not like they had a gun. It was a knife. So anyway, I think it's terrible, but I just want to say, I've seen lately these, elected officials abuse their power, whether it's elected officials, law enforcement, somebody with a title, somebody that works for a state agency that thinks they have power and they're important in all of this. I had to deal with a bully yesterday, and it was terrible. And she is definitely abusing her power. She knows who she is. But there's also other elected officials all over in our state that do the same thing. And I would just say, you don't get to do that. You don't get to abuse your power like that and weaponize that against people, because that's going to come around and that's going to get you. And especially the one who I'm talking about, you're going to see this and your time is coming. There we go.
Thank you, Ms.
You're welcome.
Judge, is it Judge Rincon White or Judge White?
White.
Judge White.
That's my legal last name.
Okay. I just want to make sure I didn't have to say the hyphenated
No.
Could you give us a bio, please?
Yes. So I have lived in Nevada for 22 years at this point. I'm from California, moved here right after law school.
What part of California?
San Diego, in the Imperial Valley area. So very southern California, near the Mexico border. And I moved from San Diego when Boyd had just graduated their first law school. And I had never been to Vegas, but I came out here because they didn't have a law school. And there were more opportunities here than in San Diego, where I went to law school. So I moved here. I've been here for that long. I was born in Mexico. Spanish is my first language. Mexicali, which is on the border with California. First generation college.
Is that next to Tijuana?
No, it's between Arizona. It's on the Arizona-California border, kind of. It's like a little Yuma, near Yuma.
Oh, I love Yuma.
Yes, Yuma. And I'm surprised you know Yuma.
I know Yuma.
Very hot down there.
Yes, it's almost like this climate.
I got lost in a sandstorm in Yuma.
Yeah.
On the Marine Corps base.
Well, it's near Glamis, the sand dunes. So I moved here after that. I first generation college graduate and high school graduate for that fact. My mom, highest level of education was third grade.
Oh, wow.
So this is a huge leap.
What about that?
Dad also had an elementary school. Unfortunately, didn't maintain a relationship with him after my parents' divorce, which I could relate to, right, in family court. Went to college, have a degree in criminal justice. I wanted to go in law enforcement, but changed routes and went into law instead. I'm married. I have now 15 years with my husband, who just retired from being a teacher. We have 2 kids, 12 and 8. And
Want to give them a shout out?
yes, hi kids. Won't mention their names, but just my family's first. So even though I maintain a very busy work schedule, my kids and my husband and I are a very close-knit family. And so that's a little bit about me. I worked in family law my entire legal career. So I'm a family law practitioner. Then I got appointed as a hearing master in 2019. and I served there for 6 years in different areas: juvenile delinquency, child abuse, neglect, domestic violence. And in March, I got appointed by Governor Lombardo to family court.
You was in truancy as well. Right?
I'm sorry?
Truancy?
Truancy diversion as a pro tem. Yes.
Oh, okay.
That was earlier. I also did pro tem in child support court. So I've literally served in every court in family court.
So out of all the levels of law, criminal, what they call those malpractice, why did you pick family? Or did family pick you?
Family picked me. I actually wanted to be in law enforcement or be a prosecutor. And ironically, my highest grade in law school was in family law. I actually amjured the class. Amjured means when you get the highest score of the entire class. And so I'm like, this is the only class I've ever amjured, right? So I decided to intern in that. And then when I took the bar and I was waiting for bar results, I worked at a law firm where I clerked as a family law practitioner. And I saw the need for bilingual family law attorneys because a lot of construction, culinary folks, right, are either prefer Spanish or don't speak English very well. And it's hard to communicate with an attorney when the language barrier exists. So I kind of fell into that, and then that became my career, and I haven't worked in any other area but that. So don't ask me about a will or about, this or that. Nope. Nope. I'm allergic to that. Yes. So I know a little bit of everything, of course, but I've never done anything other than family law.
So how does your experience as a hearing master shape you to become a judge?
Well, you know what? As a hearing master, you work a lot in a courtroom. So now I see the difference, right? I thought,
what's the difference?
I'm glad you asked, because as a hearing master, I thought, how's my job going to differ, right? It's going to be the same. But there are a lot of differences. As a hearing master, you deal with one area of the law. Okay. So the most recent assignment was domestic violence. I just had to deal with one chapter of the NRS 33. It's about this long. Now I have to deal with, NRS 125, 125C, 125B, 430, all these
Don't
other.
forget the canons.
Yes, and the canons and the EDCRs. Mm-hmm. So my level of practice went from this, right, to this, going from a hearing master. And as a hearing master, you're in the front lines, right? At domestic violence court, which I last served at, is you apply right now and you're seeing me in 10 minutes as a hearing master. You work in a courtroom, and that's where you work all day long. And you rarely do any back office work. Like decisions aren't long, like judicial ones. You don't have to prepare a big calendar, things like that. So I worked literally all day, every day in a courtroom, and it gave me the ability to handle people that come in emotional, right? Just got in a fight, just got injured. Their spouse just got arrested. So their emotions are running high. So I learned how to deal with people who come in with raw emotion. Unlike a divorce case where you sat there and thought about your hearing for 2 months, right? And had time to prepare and think how you're going to talk to a judge. These folks are coming in sometimes with fresh scratches, right? And I had to deal with them wanting a protection order, being emotional, possibly being injured, in crisis, literally. So I learned how to be patient.
That makes it even worse.
Right? 99% of the people that hearing masters deal with are pro se. Mm-hmm. So I learned how to talk to people that don't have an attorney, how to be patient, mm-hmm. right? Because they want to tell you all these things that aren't relevant, but to them are important. Right. And part of it is listening and let them feel listened or heard, right? So it's very different, and it prepared me because now that I deal with pro ses, I know exactly what to do, meaning how to speak to them, how to be patient, how to redirect when we're going off tangents, things like that. So I think it was a great experience, and I'm so glad that I had that opportunity before becoming a judge. I think going from an attorney to a judge is probably just a huge leap, but I had a little bit of training, right? 6 years worth of training before I came to the bench as a judge.
Do you handle any cases involving CPS, child abuse?
I did that as a hearing master for 2 years, full time. But right now I'm assigned to domestic cases. So I handle the divorce, the custody, but we get hybrid issues. And just today I dealt with a case involving CPS, right? So there were allegations of abuse. So I know how to read the unity notes. I know the process of CPS. So while I don't handle those cases, some of them blend into a custody case. And so I know the jargon and I know how the reports work and I know how, the department works and things like that.
When you have a case like that, that's not conclusive, where medical records it's not conclusive. There's differing opinions. Mm-hmm. Do you defer to the parents being innocent and assume they're innocent until something is conclusive? Or do you guys look at it reverse? Do you look at them as criminals first?
There's a presumption of innocence for everyone. Mm-hmm. So that's how I treat everybody. Unless you have a conviction, right? And sometimes those aren't correct. I don't treat anybody as guilty or that they did it. But I do obviously have to look at evidence also. So you walk in the door, I already know, right, that they're going to say this guy or this lady did something to their kid, but I don't treat them like that because they haven't been proven guilty. And so I listen to them and I give them the benefit of the doubt, but I look at what evidence do I have? Do I have pictures? But it's not my place to convict them anyway. I'm dealing with their rights as parents, not as their right as, freedom, things like that.
Well, I'm saying if their kids were taken away because they were, accused of hurting the kids and CPS takes them. But I would imagine that you guys would have to, if it's inconclusive, then you would have to give the kids back. If there's, you would have to do that if there's nothing solid evidence, in evidence that proves that they harmed their kids.
Right. In that world, it's called substantiated or unsubstantiated. And substantiated means there was evidence to show, right, that something may have happened. But even when allegations are substantiated, and I worked in dependency, the goal is always reunification because you're supposed to make attempts to rehabilitate people and parents. Luckily in domestic, I don't have to deal with that component. So I don't assess, reunification from the same lens that a dependency judge looks at. I look at the best interest, whereas a dependency judge looks at the safety. Obviously I have to weigh safety, but it's a different dynamic in domestic versus dependency.
What do you believe is the most misunderstood aspects of family court? You know how when you talk to people, especially attorneys, and you say, hey, you want to be a family court judge? And they're like, no, I don't want to be a family court judge. I'd rather be civil criminal, but I want to stay away from family court. What do you think is the most misunderstood?
The most misunderstood is how they take it as it's too personal, right? And nobody wants to get involved with things.
What do you mean by that?
What I mean by that is when you're dealing with families, you're learning about their habits at home, their habits in the community, their habits with their children, very intimate, personal things. And most citizens, right, if you're walking down the street and see a crime, some people run to the burning building. What do others do?
Run away.
They run away, right? So
it's not my problem.
Exactly. So a lot of people, because it's so personal and you're dealing with kids with money, they'd rather not get involved. Whereas a criminal judge, I've never been one, I've never practiced, but here's the law. In juvie, okay, a kid did this crime, this is the sentence. It didn't really matter the why they did it. It didn't matter things like that. So I think you really have to want to be in the people business to be a family court judge, because it is that. We are in the business of people. We're dealing with people. You need to know how to speak to people. You need to know how to identify their issues and offer solutions. And that's too much work for most people.
Do you follow the rule?
Emotionally invested. Mm-hmm.
Do you follow the rule of evidence in your courtroom, or do you deal by hearsay, especially when it comes from an attorney?
I follow all the rules and I apply them equally, whether you have an attorney or not, with some flexibility with pro se's when I know that they don't know the rules of evidence. Okay. And the statutes and case law say that certain exceptions, there's like children's hearsay exception, things like that you can take into consideration. But if I ever have a question about a fact, and I know the attorney does not know firsthand because they weren't there and they're advocating for their client and they're advocating for a position, then I will ask them, can I ask your client directly? And I swear everybody in at the beginning of the hearing, and I ask the question directly. But I don't like to deviate from the rules because appellate wise, right? If you don't follow the evidentiary rules, if you don't follow the local rules, any decision you make can be overturned. And what service did I do to the families? Cause them to incur the experience of an appeal, which isn't cheap, which isn't fast. So I try to follow the rules because I don't want the appellate court to tell me I got it wrong and further create an issue for a family that's already having enough problems. I don't need to be part of the problem.
When you believe an attorney is lying to the court, what are your steps?
I first remind them that they're an officer of the court. And I tell them that even though they weren't put under oath at the beginning of the hearing, they have a standing obligation and they have the rules of ethics and they have all those things that they need to follow. So I kind of give them the warning, right, where this is going. I'm never just going to lash out. I'm never just going to blast somebody. And then I say, I have information that what you're telling me is not correct. What was the source of the information? Okay. If they just tell me they can't give me the source and they just fabricated it, right? I usually say, that doesn't sound credible to me. And if I don't believe you today, it's going to be very hard to believe you tomorrow and the next day, even though your client may change. So I'm going to give you another opportunity to really tell me what's going on here. And most people at that time know, right, that they can't lie anymore. But I would, if I had to, I never have, would report an attorney to the bar if they were to lie, and I would find out. Question. And there's a penalty of perjury. It's up to the DA to prosecute this, but I would do it if justice so required it. Fortunately, I haven't been in that position yet.
One of the biggest problems I have with family court, because we hear this all the time, the judge's orders are pay child support, and they don't pay child support. Or you're supposed to pick up Johnny on a certain day, and mom isn't there, dad isn't there, and they don't follow court orders. There doesn't seem to be any consequences for court orders being broken and not followed. And I ask this of all family because it irritates me. I mean, this one litigant that we know, 6 years, no child support has been paid. And they're not held accountable. So what do you do in that situation?
Well, there are mechanisms to hold people accountable.
I know there are, but it doesn't seem like people get relief from using those mechanisms.
Well, with me, you do get relief. Okay, so I have sat in child support court where I have remanded people for not paying. I don't care if it was $50 that you didn't pay or if it was $1,000 or more dollars, but I'm a rule follower, and I just used this example today with a case. And I said, you are asking me to enforce the rules because so-and-so is not following the rules. So if I don't follow the rules, what am I telling the people who appear before me? Judge doesn't follow rules, so why do I? So I do follow rules. And there are certain things you can do. So let's just take, for example, the situation about child support. So long as the procedure is complete, meaning so long as they filed their financial form, their schedule of arrearages, Then I go through the mechanisms of giving them a deadline to pay. Okay? So you owe this amount. It's reduced to judgment, which means that now the person can go collect it against their wages, against their paycheck. You can put a lien on somebody's house. A lot of people don't know this, right? Because they haven't been told and educated, either because their pro ses or their attorneys didn't tell them. But I can't tell Steve, empty your wallet, right? Because if he has zero in there, what does that do? But I can tell the person, here's your order, which I do. Do you know where they work? Yes. Take it to human resources. Do you know where they have a bank account? Yes. Take it to their bank account. If they have $50, they're going to garnish the $50. And I guarantee you, they're going to come on their own and say, I'm sorry, should have paid. So there are mechanisms to hold people accountable. And I do hold people accountable. I've had cases, and I could give you examples. I've had cases where people owe 5 figures. Mm-hmm. And I say, this is reduced to judgment. You have 90 days to pay. But no, Nevada imposes an obligation for all parents to support their children, right? You're only paying 16% or whatever percent of child support is. Where's the other percentage coming from? From the parent who has it. Why should you get away with 16% and this person has to bear 100%, really? So I do enforce orders, and I have remanded people for not showing up in court when they were ordered to do so. I have issued warrants when people don't return their children when they are supposed to. I have remanded people when they don't pay child support. So you're not looking at a judge that allows people to get away with things.
I wish all the judges would be that strict, because I think some of these people, especially, people that are self-employed, they don't have a paycheck that you can garnish or, whatever the case is. And a lot of these people have the money to pay, but the judges, if they're friends with them or, whatever the case is, they get let off the hook. But I'm glad you're not.
There are ways to do it. I can't enforce it for you, but I always direct people, this is what you can do. Now, if you go do it and bring me all the paperwork, I'll do it. But I can't sua sponte, right? Issue a warrant when no one has requested a warrant. So I always do my best to inform pro ses. These are your options. Go figure out how to do them. And if you do, I'll help them. The only time that I don't force people to do something, I'm going to be very candid, is when they don't pick up their kids. This is shocking. I can tell by your face, but this is why. If you don't want to pick up your kids, okay, why would I force someone who doesn't want to pick up their kids on their own to take their kids when they don't want to take them?
Yeah,
having your children should be a joy. Mm-hmm. Shouldn't be a burden. It shouldn't be because I have to, because at the end of the day, the kids are going to be not treated well. And I have those situations where I have to look at a parent who's frustrated because they have the kids 24/7. A lot of them don't have childcare. But when I shed that light on them, they get this like, you're right. Why would I shove a kid down somebody's throat? Yeah. Why? So you could go leave the kid at a casino daycare all day. Mm-hmm. So you could leave the kid with the neighbor home alone. The kid is exposed to more neglect and danger if you force a parent. I'll reduce their time. You could do an upward deviation on child support. On someone who doesn't want to take their child, it's allowed by statute. You could increase their child support for childcare. There are other mechanisms to get them to help out with the kid without forcing them to take their child when they don't want to.
What is the age where the child can tell you, I want to live with mom, I want to live with dad?
That's a great question. If you open the NRS, you're not going to find a number. Okay. It's called, it's factor 1 of the best interests. And it looks at whether the child is of sufficient age and maturity to make a decision. I have had 16-year-olds that aren't mature enough. Even though they're 16, here's why. They're flunking out in school. They're running away, right? They're not obeying their house rules, things like that. A child like that tells me that they're making poor decisions and doing things against their own best interest, right? But then I can have a 12-year-old that is articulate, that can articulate. I don't want to see my parent. Why? I don't know. Okay, well, but if they can articulate because they did A, B, C, D, I always use the analogy that the older the kid is, the more mature the kid is, the more responsible, their voice gets louder. But I have the discretion to say, I'll hear what you have to say, but I'm not necessarily going to do what you tell me to do, because I have to look at, are you a good student? Are you really making good decisions? Because if you're not making decisions out in the community, then I don't know if I can trust you with this decision about which parent you can see, because they could manipulate you, right? With the things you want. Don't go to school, honey. Don't turn in your homework. Is that in the child's best interest? So to answer your question, you're not going to find an age number in the statute. It's the discretion of the judge. And my philosophy is I look at the big picture, right? Are they eating all their vegetables and a little bit of ice cream, or a lot of ice cream and one broccoli a year? You have to look at all that stuff.
I love it.
So at what point would you remand something to judgment as far as child support or alimony is concerned?
Remand? Well, the statute says you could impose 25 days in jail, but you also have to weigh the fact that if you put someone in jail for that long, you have to weigh how much is it costing us to put that person in jail. And if I put them in jail for that long, chances are they're going to lose their job. And now what did I do? Create a bigger problem. So it is okay to impose a balance in child support court. 5 days stayed if you pay this by this amount by this date. If not, you're being remanded. 10-day, something reasonable. You could even do a weekend jail program where they go in for the weekend and come out to go work Monday through Friday. So there are a lot of options on there. But let me tell you, the court of public opinion, right, has a lot of opinions, and I'm cool with that. But until you sit in that chair, you don't realize how many things a judge has to juggle. You're like a juggler. I use that analogy too. I have to juggle your interests, the kid's interests, the law. I mean, try doing that. I have a caseload of about 500. Try doing that for 500 families.
Have you ever conducted a judgment examination hearing?
Yes, I have.
In your courtroom and family court?
Yes. And an attorney judgment. I don't know if you want me to explain what that is.
Yeah, I do. And because you mentioned go in your pockets. Do you have them go in their wallets, empty their pockets out, put it? I've done that. I have done that.
I have actually commented on people's shoes. Like, oh, you have an empty wallet, but I see you're wearing the latest Air Jordans that I can't even afford. You see in the audience, the rings coming off, the phone's being put away, because they know I'm watching people from the minute they're walking in. I'm not buried in my computer. I'm watching because I take safety seriously. So I'm looking at that. I'm looking at, are they already giving each other the side eye? I'm watching people from the minute they're walking in. But to answer your question, yes, I've had attorneys ask me to conduct that examination where they come in the courtroom, they're sworn under oath, and the attorney goes through how many assets they have and where do they have their bank accounts, because that's another tool of being able to garnish. Everyone has something you could take that's going to hurt them, that will eventually get them to like, ooh, I better start paying, or they're going to take, what I like, my baseball card collection.
Only if the judge enforces that, because there are some judges where there's friends with, the father or whatever, and the father is rich, is an attorney, self-employed, and they get off, scot-free. And this is a different role for me, but the way I'm seen is I'm elected by the people, not by the attorneys who appear before me. So I am serving in that capacity. And while I know a lot of attorneys, because my career in family court has been 18 years long, and I know from the janitors to the court clerks to the attorneys and their paralegals, that doesn't mean I'm their friend. I know how to turn it off and turn it on. And I think that's probably why you won't see me chummy with someone, because I would walk in as an attorney and I would see a judge
hey, what's up? How was your golf this past Sunday? And then my client's over here feeling like, oh my gosh, they're scared. They know the attorney. They're going to do them a favor. I have friends appear before me. You would never even know I know them because I address them. Counsel, your appearance. Good morning. Very neutral. I never ask, how's your son doing? Even though I may know what's going on with their kid.
Why do they do that from the bench, though?
I think I feel uncomfortable doing that.
It doesn't look or sound right. No, I agree with that.
So you would never know who my friends are because I don't treat them like my friends at work.
Good.
When would you deem a litigant or an attorney for that matter, which I've never seen with the attorney, vexatious?
Well, there's case law that tells us about vexatious litigants and what it means. And you'd have to go through the factors. It's the Jordan case to see if they meet the standards of vexatious. Just because they annoy you doesn't mean they're vexatious. It has, you know what I mean? I have people that are like, you're here again. You're here again. That's not vexatious. Mm-hmm. It's how many lawsuits have they filed? How many filings have they had in the last year? Did they have a reason to file, like a legal reason or not? To be perfectly honest, finding someone a vexatious litigant is a long process. There's a list of factors you have to analyze. And if you do find someone a vexatious litigant, that does not mean they can never file again. It means that now every time they want to file something, they have to ask the judge for permission before they file it. So that's probably why people stay away from finding people vexatious, because now every time they want to file, they have to get your permission first. I haven't had a case like that yet, but I know the case law that applies and what I would have to do if it were the case.
How come an attorney is not deemed vexatious?
Because they're not a litigant. But they're the representative.
They probably do more filings than the
then go
litigants.
Report them to the bar.
Would you do that?
If it was necessary, I would. I wouldn't just do it to ruin someone's career or because they gave me a hard time. But if there's a legitimate reason where an attorney has either appeared under the influence, has been so reckless that they've basically, I don't want to say hurt their client, not physically, I don't mean it physically, but hurt their legal position. If I had to do it, I would. But I've only been on the bench 4 months as a judge, and I haven't had to do it yet. But
have you done relocation or termination of parental rights?
Yes.
And what do you look for when you do that?
I have had probably so many trials on relocation in the last 5 months. You want to go to Puerto Rico? You want to go to Hawaii, Chicago? I've done all those places. They're not easy. Emotionally, they're hard because you're basically taking a child away from two parents, allowing one parent to move away. Generally, it's far, and it could really damage the relationship to the party that stays behind. So you have to take them very seriously. But there's case law and factors that we need to look at. I have granted them and I have denied them. It depends on the case.
Do you think that one judge should be able to do that, or do you think it should be a jury or a tribunal?
You know what? Because this is such a personal business, I don't think I can trust a jury to decide this, because it's such a personal, you shouldn't take certain personal things into consideration. When I'm on the bench, I'm not judging you personally. There's a difference. I could sit here and judge you based on how you're dressed, based on how you speak personally. But when you're on the bench, you have to judge them with a legal lens. And I don't know if a jury can do that when they're lay people and they want to insert their beliefs. If they don't agree politically, we could sit here around the table and say what's good for kids. And I don't think the 5 people here could formulate the exact list.
When you say personal, what do you mean exactly? Because rape is personal and they have a jury for that. So why wouldn't they have one for relocation?
Because we're not dealing with a statute that tells you what best interest are. Best interest is such a big word. Again, we could sit here and define, it gives you a judge so much discretion, right? And I know what best interests are because I know the 8 factors by heart, right? And I can see through people manipulating one child against the other. I can look at all those things, but I don't know if a jury can look at what you feed your child, what you dress your child in, and be unbiased.
What about a tribunal? 3-judge panel to decide relocation or termination of parental rights. Because that's a big thing.
That would be a good checks and balances. Yeah. I don't think I've ever thought of that, but I think it would be a good checks and balances because, again, 3 legal minds analyzing the same problem is different than 5 civilian people who don't have the legal training to analyze the issues. And again, when I go on the bench, I'm looking at you from a legal lens, not from what Adriana thinks you should be feeding your kid.
Broccoli.
Yeah. Or you
Drop it at least once a year.
Yes.
What's the threshold for terminating parental rights?
Well, you have to go through the whole gamut of NRS 128. Have they abandoned the child? Have they been neglecting the child? Have they been abusive of the child? You have to go through all that. And when I was in abuse and neglect, I did go through a lot of termination of parental rights. And I do them now in a private setting, not from the Department of Family Services. So no one has said this person abused their kid. It's the other parent saying it. And I have to see if there's enough.
So it's not just one of those things that you mentioned. Do they have to meet multiple?
It could be one of those.
Just one.
It could be one is good enough. So
even if it's not conclusive.
By conclusive, you mean they haven't been convicted?
Let's say it's abuse and one parent, this is abuse. A doctor says, oh, well, this is what we've determined, but then there's alternative opinions. Does it have to be almost 100% conclusive before you take away a parent's rights?
No, that's not the burden. The burden is either clear and convincing evidence or the preponderance of the evidence, which makes it 51% or more.
Shouldn't it be a little bit higher bar than that?
Well, I didn't write the law, right? That's the legislature. So I'm not here to tell you what I think about the law because I'm not a legislature. And that's another thing. I don't legislate from the bench. I don't rule based on what I think the law should be because that's not my job. And I respect my job. I worked very hard to get to this point, and I'm not going to start legislating and saying, nope, the law says this, but I'm going to do. No, I've been charged with the big responsibility. And I think that that's what people want. Mm-hmm. I think people just want judges to enforce and apply the law. They don't want a judge to give their personal opinion.
Yeah.
They're not there to hear what I think. They're there to say what I think based on the law.
What about cases that are sealed? Some people want cases sealed because maybe there's some high profile, highfalutin doctor or something, and their reputation is at stake. Has nothing to do with the children or anything like that. When do you grant that?
Well, the compelling interest has to outweigh, the compelling reason why they want it sealed has to outweigh our right to be in a courtroom because it's funded by the public. I'm elected by the public, and they should be able to know how the system works. I think it should be transparent. So I need to know why you're asking me to seal. If you're asking me to seal because you don't want your nosy neighbor to know that you cheated on your spouse, that's not a compelling interest.
What about their reputation?
That, depending on what reputation are we protecting and why?
Yeah, who's more important than the other?
Well,
nobody.
Tell me some facts.
What if they're an elected official? Mm-hmm. What if they're in law enforcement? What if they're a celebrity? Do they have any? Are they special compared to other people wanting to protect their reputation? So
I think Joe Smith and insert celebrity here can both apply to seal a case, and I would look at it. Why? Was a child raped? That I don't want the public to know because that's going to victimize the child again? Is it you just don't want, you're a pastor and you don't want them to know your little secrets? That's not a compelling interest in my opinion. So it's hard to sit here and speculate, right? We could sit here all day and debate it, but I'm looking at from, is it going to harm, like injure somebody, injure a child's life more by the public knowing these things, right? I'm more for like a child, no question. I'm going to seal that if it's going to protect a child. The adult, it depends on why we're seeking that. If you just don't want people to know you're really a dirty person, I don't think I can protect that. But if you're going to get hurt, you're going to, we just have to look at the facts one by one. I don't treat people with a blanket. Your story, and my story are different. So I have to listen to why you want it done.
Have you reviewed SB 432?
Yes. Mm-hmm. And it tells us that you have to articulate in written findings why you're sealing a case. You have to weigh, again, the interest of the person requesting it and the public, the public's right to know what's going on in family court.
So here's a hypothetical for you. Litigants and their attorneys show up before you.
Okay.
And attorney looks over his shoulder and see court observers in the room.
Okay.
And now says, hey, judge, I want a closed hearing. What does the judge say?
I don't know what a judge says, but I would say, why? Because they're court observers. I'm not granting that request. You're telling me that the person that the other spouse brought has been harassing you and has threatened to hurt you after the hearing. That person is going to go outside. But just because somebody's watching, I've had people, I don't want the mother-in-law sitting in here. Why? Because I don't want her to know our business. I'm sorry, mother-in-law has a right to know what's going on. She could go get
the doggone audio recorder or whatever it's called.
So,
what is it called again? The
JAVS video? JAVS. Yeah. So court observers are not a reason to close a hearing.
What weight do you give DV without a police report, without an arrest, without a conviction, just litigant just saying that I've been a victim of domestic violence for many years and I was fearful and I didn't want to report it, but you don't know if they're just making that up or if it's actually a true statement. So what weight do you give that without any evidence?
It's probable cause. It's the same as a probable cause arrest, right? That's the level that a judge has to apply. So as a judge, you are the trier of fact and you get to weigh people's credibility. And
how do you do that?
I can't tell you all my secrets, but I know when people are lying to me.
The public wants to know.
I know when people are lying because I'm very detailed oriented.
You're a lie detector.
I could be a human one. Ask my kids. They don't get away with anything.
Most moms are, I think.
I pay attention to detail, honestly. And I have a law clerk, but I read everything myself. And although my law clerk helps me brief, it drives her nuts that I still brief my own cases. Not because I'm double checking her, but because I know after all these years how to look at details and weigh them and how to question people on detail, a detail that was given here and a detail that's given 5 pages later, and it doesn't match. I'm going to catch that detail. It's one of my talents. I don't know, but you don't need a police report for domestic violence. You don't need an arrest. You don't need a conviction. It's defined in the statute what you need to look for, and it's probable cause. That's enough. And probable cause could be that this person has enough information to convince you that something did happen. A push because they have the video. They have a mark. They have a torn shirt. Now, the other person has due process rights too. They have the right to request a hearing, and I'll listen to their story. And then that's where my skills come in to figure out who's telling me the truth. Do I get it right all the time? Of course not. I am human at the end of the day. But I just in TPO court, I did 50 or more applications in a day. You'd start learning how to pick up on things, and you start asking questions for the little details that people don't think they're going to be asked about. And that's generally when you catch people in a lie. Did he slap you on the left or on the right? What judge would ask that? Did they use a pencil or a pen? Because they stabbed me with the writing on, I'm simplifying it, but I'm good at detecting lies and contradictions.
You ever thought about working for the FBI?
That's actually where I wanted to go with my degree. But then in the 90s, they wanted accountants for some reason, not criminal justice majors.
Do you have anything else for Judge White?
Yes, the question I always ask female judges: do you have a CCW and do you carry behind the bench?
Do I have to say that?
No, you don't.
No, you could pass on.
I will not disclose that.
Okay.
Judge White, is there anything else that you wanted to?
I just want to say that being a judge is not an easy thing. And a lot of the work for a judge does not happen in a courtroom. I work a lot of hours. I work almost every day, a little bit at a time if I need to, but I work every day because I have orders to review, cases to prepare, things to prepare for. So a lot of the work that a judge does is behind the scenes.
When's your admin day?
Fridays. And I picked Friday. There's a reason for Friday. Because I think it's a disservice to clients to set hearings on Fridays because most attorneys don't want to appear in court on Friday. And they're going to want to kick it out. They're going to not take a case because if the trial's on a Friday. So every judge should take a day, and an admin day. I don't know how other judges treat their admin day, but my admin day is not a free day. I have a 3 a.m. setting on my admin day. That means that you can file a motion, not request a hearing, and I decided on the papers. So on Friday mornings, not at 3 a.m., from chambers, I sit there and read motions. I have 6 settings on Friday.
What do you put it at 3 a.m.?
Because if you set it between 9 and 5, people are going to think they come to the courthouse. And in 3 o'clock, they're going to be like 3 o'clock in the morning.
I'll be there.
So I'm not the only one. That's a court-wide setting. You're in chamber. So I decide cases on Friday. I prepare for the next week on Friday. I wrap up any decisions I have from Friday. And I need a day where I could just do paperwork that I don't get to do when I'm in court for hours and hours at a time.
You have anything else, Ms. Phillips?
That's it.
Well, Judge White, I want to thank you for coming on the program.
Thank you.
And Mark's going to zoom in on you. And this is when you can say whatever you want. Vote for me. I'm running for re-election. Here's my website, whatever.
Okay. So I was appointed by Governor Lombardo in March, and I will be on your ballot for the November 2026 election to start my term of retention in 2027. So I am running to be retained as judge. I have experience in family law. That is the only area of the law I have worked in. And I have 6 years on the bench, even though I've only been on the domestic judge bench. So I have experience. And I do believe that a judicial position is of the people. My courtroom is open because I want to be rehired. And the only way you rehire people, right, is if you know how they work. So Department Y, currently I'm in courtroom 14. My marshal knows that the door is always unlocked while I'm on the bench. Unless he's not in there, then he has to lock it because I can't be in there by myself without a marshal and the door unlocked. But the door is unlocked for Department Y, currently courtroom 14. And I hope people vote for me. I do not have a website yet, but I do have a page on Instagram where I post just judicial events and things that I participate in, such as CASA. I'm a big supporter of CASA, and I go to all their events because our children are the ones that need voices from all professional levels. So thank you for your time.
Well, Judge White, thank you so much for being on the program. Thank you, Ms. Phillips. Folks, that's Adriana Rincon White, Clark County District Court Judge, Department Y, Family Division. We hope that this program is beneficial and educated you on this particular judge. And when you go to the voting booth, you'll be an educated voter. This is Steve Sampson, Stephanie Phillips with Veterans in Politics. Until next time.